Okay, Lindsay, do we have everybody in?
Yeah, so far, maybe just give it, 30 seconds or so, let everyone trickle in, or you guys could start introductions while they're trickling in. That'd be awesome.
Yeah, well, let's go ahead and start with the introductions then. So good morning. Welcome to the 2026 Employer Update. My name's Aaron Carmack. I've been with Cardinal for about 27 years, about 20 on the HR team. Also with us today is Tomas Chavez. Now, if you've had an HR ticket with Cardinal, there's a decent chance you've spoken with one or even both of us. Tomas?
Hi, everyone. My name is Tomas Chavez, and I've been with Cardinal since 2016. I've been the HR director for nearly 5 years now. And a fun fact, I'm actually located in Cardinal's California office, which I feel gives me a little bit of a leg up because, as most of you know, if California adopts a new labor law, chances are Oregon isn't too far behind.
Okay, before we get started, I want to do a little bit of housekeeping on here. Just to mention that Teams has crashed on me twice today. So if it does crash, it seems like I can get back in about 30 seconds there. If you have any questions, please put those in the chat. Lindsay's going to be compiling those, and then we'll have a question and answer thing at the very end. And Terry, I think you're letting in any stragglers. Thank you, Lindsay and Terry, for keeping on top of that. And with that, let's go ahead and get started. We're going to be doing the usual webinar in that we'll be talking about stuff at the federal level, state of Oregon, upcoming item of interest, and then finally what's happening in Washington and California. So starting off here at the federal level, we've got the OBBBA. It seems like a lot of these acronyms have a nickname of some sort. I'm not familiar with one, so I'm just going to call this the Big Beautiful Bill. And for employees that looked at this headline of, hey, there's no tax on tips and overtime, we got some phone calls on that because, hey, Cardinal, you're still taking out overtime taxes on my overtime. And so we'd have to explain to them that this is actually a tax credit on tips and overtime, and then to add in this just on federal taxation on there. Now, employees that didn't pay attention to the headline or didn't pay attention to their pay stubs, they're going to be pleasantly surprised when they file their taxes because they can get up to a $25,000 tax. Oh, it's retroactive through 2025. So they can get up to a $25,000 tax credit on tips or up to a $12,500 tax credit on overtime. Now, I mentioned this was retroactive through 2025, and overtime is easy because overtime, it's real clear on the W-2. Overtime is just overtime. But according to the IRS, that tips are not just tips. Apparently, there's a difference between voluntary and involuntary tips. Voluntary tips go towards the tax credit, whereas involuntary ones do not. And so some examples of voluntary tip would be you go get a cup of coffee and you tip the barista $1, put it in the tip jar. Now, an involuntary tip could be something like you have a service delivery fee for a pizza and $3.50, that service delivery fee goes to the driver. That's an involuntary tip and not eligible for the credit. You go to a restaurant, parties of 10 or more have a mandatory and automatic 18% gratuity. Once again, not eligible for that tax credit on there. So you'd actually have to try to break that out. But even if you did break it out in 2025's W-2, there's not two different boxes for that. And the problem is, even if you could break it out, I mean, I don't know of any employers that actually broke it out in 2025 because they didn't know this was coming on there. I have heard of employers going back and creating a supplemental report where they can review their records and break out between voluntary and involuntary taxes and give those employees a copy of that. So moving forward in 2026, the IRS is coming out with a new W-2. And so what we did was we reached out to any employers that had tips in 2025 and said, hey, we now have two different buckets we can track these in. If you let us know the differences for the tips, we'll put those in the correct places so they go on the W-2 correctly. I should mention that we have an article on our website. And I remember when I was putting together that article on the Big Beautiful Bill, that included a link as to the IRS's definitions of voluntary and involuntary tips. So Secure Act 2.0, Now, this has been around for a couple of years, and the basic idea is Americans aren't saving enough. So Congress created Secure Act 2.0 to have administrative changes to 401k plans to get people to save more money on there. Now, I know that in terms of compliance and education, for Cardinal's 401k plan, I got a notice in the mail listing all the different changes that happened for the 2026 year. To be honest, I stuck that in the drawer. But to my defense, I'm pretty familiar with what's going on with these. Some of the big ones, I mean, there's lots of little stuff behind the scenes. For example, highly compensated employees, they finally figured out they have to now, if they're going to use a 401k plan, they have to use a Roth 401k. So they're paying taxes on the front end of that. The big ones on here, the 401k contributions. We've had catch-up contributions before. For employees that are 50 and over, you can contribute an extra $8,000, but now we have a new category of 60 to 63, and they can contribute an additional $11,500. The other one that is of interest is this expanded enrollment on here. So now you have to have automatic enrollment. So employees have to specifically opt out. Otherwise, the 401k contributions just kick in automatically. And that's required for new 401k plans. And when I say new, that's as of December 29th, 2022. We actually had employers that set up 401k plans where it was voluntary, and then suddenly it had to change to automatic enrollment on there. And the whole idea is with this, with automatic enrollment, is that, hey, I know I probably should go into a 401k plan, contribute 5% or whatever on there. And if I'm automatically enrolled, maybe I'm not going to jump through the hoops to get out of that. The problem is in those type of situations is that it can ruffle some feathers, because with the automatic enrollment, maybe the employee on their first day of hire, they see that, oh, there's a 401k plan, but it's their first day on the job. They're busy trying to just do their job for the first day. Then this enrollment comes around, they get an email, they get something in the mail, and like me, just stick it in the drawer and ignore it. And then suddenly Cardinal's taking money out on the 401k plan with these automatic enrollments on there. So we have to explain the law to them and help them if they want to get the money back out in those situations. Okay, moving on to the final thing at the federal level. If you're an employer and you provide childcare to your employees, sorry, that kind of strikes me as funny. I'm not implying that. If you're an employer and you provide childcare to your employees' children, there's a possible tax credit out there. Now, I'm not going to get into specifics on like what is the definition of a small employer to be able to get those tax credits. But the takeaway here is that if you are or planning to provide childcare, you should look at this. And Lindsay just put in the chat a link to the childcare tax credits there. Okay, moving on to the state of Oregon, I should first note that we're going to go over 11 bills that are already in place, either when they're signed or first of the year, that type of thing, except for one, and we'll be sure to highlight that for you. If I was to sum up what's gone on in the Oregon legislature in 2025 for new stuff, it would be an expansion or additional groups or other things to existing laws for the most part on here. There's nothing big like an Oregon Saves or Paid Leave Oregon. And over to you, Tomas.
Thank you, Aaron. So the first Oregon bill we're going to talk about is House Bill 3991. And this bill has a number of tax provisions, with the core provision being that it was set to double the state's transit payroll tax from 0.1 to 0.2%. That provision of the bill has been put on hold, and it's not going to go into effect. So the moral of the story is if you've made changes to your payroll system for that tax, you need to change it back. Not much more to say about it other than that, and it's important. You don't want to double that rate if you don't have to. Next slide, please. So Oregon House Bill 3187 is the next one we're going to talk about, and that officially took effect on September 26th of last year, 2025. This is a significant expansion of Oregon's age discrimination laws. Its primary goal was to reduce early stage bias by preventing employers from screening out older candidates based on birth dates or graduation years or things like that that you might be able to see before that candidate gets to an interview. So some of the key provisions of the bill are that employers and employment agencies are prohibited from asking an applicant's age, date of birth, or the dates of attendance or graduation from school during the initial application phase. Those questions can be asked after an initial interview has been completed. If you didn't have an interview with the person, then you can only ask those questions after you've given a conditional job offer. There are a couple exceptions. Employers can still ask age-related questions if they're a BFOQ, and that's a bona fide occupational qualification. For example, if someone's applying to work as a bartender, or someone's working to be a pilot, something like that. And it's also, of course, if it's required to comply with specific federal, state, or local laws. So if that's the case, then you can ask. But in general, you definitely want to avoid the age discrimination type of questions. All right. Back to you. Oh, no, that's me. Excuse me. House Bill 2541. So this bill expands existing lactation protections to include agricultural workers who were previously exempt because the rights were their rights under certain piece rate and seasonal work definitions didn't fall under the previous bill. So this ensures that agricultural employees, including those that hand harvest and pruning laborers who are paid on a piece rate basis, have the same legal rights to express milk as other employees in other sectors. The bill says that employers must provide reasonable, unpaid rest periods for an employee to express milk as often as they need for a child who's up to 18 months of age. Employers are required to provide a private sanitary space in a generally close proximity to the work area, and this cannot be a public restroom or a toilet stall. The bill also mandates that school district boards adopt a specific policy designating private locations for employees to express milk, and they must publish these locations in their employee handbooks. There is an undue hardship exemption for this, which says that employers with 10 or fewer employees might be exempt from providing these rest periods if they can prove that doing so would cause an undue hardship defined as significantly difficult or expensive relative to the size and resources of the business. And to be clear, the bill does not state that, the bill does state that while the rest periods are mandatory, employees are encouraged to take their breaks with regular meal periods or their regular breaks if that's feasible. So you don't always, you can ask them to try to take them with those, but you do still have to give the unpaid time if it's requested. And now back to you, Aaron.
Sorry if I can unmute myself. Okay, so House Bill 2957. This is just extending labor law enforcement window in certain situations on there. And I'll get into actually how that would work on your, but this really is important only if you're an employer that destroys records based on the statute of limitations for labor laws on here, because it would extend that window by 90 days in certain situations. So at Cardinal, we don't delete things like that. So you should be keeping records on employees like written warnings, write-ups, terminations, performance improvement plans. Now, actually getting into the weeds on how that 90 days works is that in Oregon, an employee or former employee, they can go to BOLI, the Bureau of Labor and Industries, or they can go to civil court, or they can go to BOLI first, and BOLI issues a right to sue letter. Now, under the old law, they would only have 90 days. Now that's extended to the statute of limitations on that. But let's say that BOLI issues that right to sue letter a day before the statute of limitations runs out. That letter then gives them that extra 90 days in those situations on here. Note that there are some other things behind the scenes, like if you're in a civil court case and you get into a settlement, there are some timelines that need to be added in. But I assume you'll have a lawyer at that point, and they'll know exactly what to do in that situation. Okay, House Bill 2248. This is good news for employers in that if BOLI, the Bureau of Labor and Industries, issues an advisory opinion, and employers acting on good faith based on that advisory opinion are protected. And not everything is going to be covered in administrative rules or laws on there. And so sometimes BOLI has to step in with an advisory opinion. And to be fair to BOLI, they can get things wrong. Things are complicated. I remember back when I was first doing HR, if you can remember back in, this is like 25 years ago on there, Oregon came out with medical marijuana, and the law was all about, hey, Oregonians can get this medical marijuana card on there. It said nothing about whether or not employers had to accommodate that in the workplace. Boley issued an advisory opinion in that situation, went to the Oregon Supremes, and they said that Boley was wrong. But if something like that were to happen again, you would be able to rely on that. So good news for employers. House Bill 2688. So if you're a subcontractor working with a general contractor or a prime contractor on a public works project, some of the additional work that you do, like it says on the slide, offsite and ancillary activities, those can now be subject to prevailing wage laws. So just something to know if you're in that field. Now, unlike these other ones, this is effective for new contracts July 1st of this year. And back to you, Tomas.
Thank you, Aaron. All right, so keeping with the theme of Oregon-related bills, the Senate Bill 69 amends Oregon's job-protected leave laws by expanding oversight, clarifying eligibility, and making procedural changes to the paid family and medical leave. So again, nothing major, but some good clarification, I'd call it. The bill clarifies that OFLA leave for a sick child or a child whose school or childcare is closed only applies if the child is under 18 years of age or is an adult child with physical or mental impairments. And remember, OFLA is unpaid leave. Beginning January 1st, 2026, the OED is authorized to share specific benefits amount with employers. This helps us, the employers, calculate the top-off pay. So say an employee makes $1,000 per week and they normally get $900 in PLO, they can use $100 of other paid leave they might have available. Previously, it was somewhat difficult to figure out what their benefit amount was and calculate that top off or give it accurately. So this should ease some of that for us employers. And then under Senate Bill 69, something that was implied but is now codified is that employers can require an employee returning from medical leave to provide a fitness for duty certification from their healthcare provider. Now, this is only allowed if the employer does it uniformly and applies this policy for similar situated employees, which is basically all of HR, right? You do for one, you want to be uniform for all. And then finally, one other thing that this bill did is give Boley oversight for retaliation and discrimination claims to PLO. So that kind of just clarifies that as well. Next slide, please. Senate Bill 426. So this bill essentially says that if a worker isn't paid, the responsibility doesn't stop at their direct boss. It can travel all the way to the top. Property owners and direct contractors or general contractors are now responsible for the unpaid wages of employees of any subcontractor, no matter how many tiers down the chain that worker is. The property owner or general contractor can be forced to pay a worker's wages even if they already paid the subcontractor for that specific labor. So there's a chance for the double payment risk. The law specifically protects workers who are not covered under collective bargaining agreement, so non-union workers, and that's because union workers are generally excluded. They have their own legal mechanisms to recover their wages. And unpaid workers, their representatives, or the attorney general can file civil actions. The recoverable amounts include unpaid wages, fringe benefits, interest, attorney's fees, and penalty wages up to 30 days of pay. Now, there's a little bit of good news here that before a lawsuit can be filed, the worker must send a notice via certified mail. The owner or contractor has 21 days to pay the owed wages to avoid litigation. The exemptions to this bill are that primary residences, so construction or renovation of your own home is exempt, which is, I think, a good thing. Developments involving 5 or fewer residential or commercial units on a single tract of land is also exempt. And of course, government entities are not considered owners under this liability. So those are the 3 main exemptions to this bill. And that's the next one. Senate Bill 1108 amends existing statutes to add blood donation as a protected use of accrued sick time. To qualify for that leave, the donation must be made through a voluntary program approved or accredited by the American Red Cross or the AABA, which is the Association for the Advancement of Blood and Biotherapies. So while employees use their accrued sick time, the bill specifically allows for only up to 4 hours of leave per year for this purpose. So hopefully it doesn't get abused. And always remember, it's unlawful to deny this leave or any sick leave or retaliate against an employee for requesting to use it for the right purposes, the approved purposes. And back to you.
Okay, thanks, Tomas. So Senate Bill 906, this is mandating detailed itemized pay statements for pay calculations on there. So think of a pay stub, a paper pay stub. You have on there HOL-8 hours. You create a guide that says HOL stands for holiday leave. So the employee can know that they got paid for not being at work. That's holiday leave. And also it's useful for noting that that doesn't get used for calculation for overtime as well. Or there's a deduction code on their pay stub and it says SUI, and they can go to the guide and see that it stands for State Unemployment Insurance Leave. Now, what Cardinal did is we just created a big guide with all of the pay codes, all the deduction codes, and things like the benefit contributions as well on one web page, and then we're just going to update that on a regular basis. And Lindsay, would you put that in the chat so people can see what employees can look at in terms of payroll deduction codes? Thank you. Okay, moving on, we've got Senate Bill 916. This enables employees on strike, union employees on strike, to receive up to 10 weeks of unemployment benefits. Now, this has been a priority for labor for a number of years. I've seen similar measures introduced in previous sessions on there. This looks like to me kind of a compromise, because I was going back and I like to follow these different bills as they go through and read some of the testimony, and there were concerns over the solvency of the trust, the unemployment trust fund in there. So it looks like instead of 26 weeks for normal unemployment, it's a compromise with 10. And as the notes on the screen state, this does give unions more bargaining power. Okay, we've got an upcoming development that I talked about last year in the webinar, and this is still going on. But if you didn't attend last year, I'll just give a recap on this. The Oregon legislature, they wanted a study to adopt a universal health plan. Now, when I say universal, they want to include Medicare in with that, and then report how they could actually do this back to the legislature by mid-September of this year. And I've been closely following along with this, particularly the Finance Committee. I've even submitted testimony to them. And they're looking at the possibility of implementing this in 2032. Now, this is the other thing on here for funding on the screen for employers and employees. As expected, employers and employees would be paying for quite a bit of this, but more specifically, this is businesses and personal income tax are making up the bulk on this. So it's an interesting study, and I should give the disclaimer, I have no idea what's going to happen with this. I mean, the legislature, they could adopt it as is. They still have a few months to go. This group has a few months to go to put this together. So this isn't even the final product, their final thing that they want to submit. Maybe the legislature goes ahead with a universal health plan and does something different for funding. I mean, they could, I don't know, probably not a sales tax, but some other type of funding out there. Or the legislature could ignore this altogether. So I know this is an employer update, and so I'll state the same thing that I said last year during the webinar, that they're really trying to spread out where they get the revenue for something like this. So if you're an employer with health insurance, if this went into effect, your costs would go lower. And obviously, if you're an employer without health insurance, your costs would go up. Okay, let's move on to Washington and California and back to Tomas.
Thanks, Aaron. So I know everyone's temptation is to tune out. Now we're done with Oregon. That's what I needed to know. But as I mentioned in the beginning, remember what our bordering states do, we frequently mimic in some degree. So it's worth wrapping your mind around some of these concepts and some of these things that are going on in Washington and California. So first, Washington's Senate Bill 5525. So this is known as the Mini WARN Act, and WARN stands for Worker Adjusted and Retraining Notification. So this act, excuse me, The act requires that covered employers provide 60 days written notice to affected employees or their union and the Washington Security Department before a mass layoff or business closing. Excuse me. This applies to any private employer who has 50 or more employees in Washington. Now, for context, the federal law only applies to those employers who have 100 or more employees, so this is even more stringent. Under this act, a mass layoff is defined as a reduction in workforce that affects 50 or more employees within a 30-day period. Crucially, Washington's version does not require these 50 employees to be at a single site, so it can apply to 50 employees spread across multiple locations within the state. Employers must explicitly state in the notice whether the layoff or closure is a result of relocating or contracting out their work. In a significant departure from the federal law, employers are generally prohibited from including employees who are currently on Washington's paid family leave in their mass layoffs. So these employers must remain employed with continued health coverage until their paid family leave claim ends. I don't know how that works, but that's specifically written into the bill, and that seems like that is going to be a tricky one. So there are a few exceptions to the bill. Natural disasters, of course, so floods, earthquakes, or storms. If that caused the layoff, then that's an exemption. If there's an unforeseeable business circumstance, so a dramatic action outside of the employer's control, if the company was faltering and the employer was actively seeking capital to avoid closure and providing that notice might have jeopardized their funding efforts, then you're exempt from giving that notice. And finally, construction projects. So if layoffs are the natural end of a specific project where the employees knew their job was temporary, then of course you don't have to give them notice. And next slide. Last thing we'll touch on for Washington is Washington's state pay transparency law. And California has one that's very similar. Originally effective in 2023, it was significantly amended last year, and it requires employers to be upfront about compensation and benefits in all of their job advertisements. This law was designed to close the gender and racial pay gaps by giving applicants more negotiating power. However, there were some unintended consequences, and they found a wave of bounty hunter lawsuits from individuals who applied for jobs solely to sue for any missing salary information. So the legislator made several common sense fixes that took effect on July of 2025. So key provisions in the bill say that a salary disclosure is where employers with 15 or more employees must include a wage scale or a salary range in every single job posting. Postings must include a general description of all benefits like healthcare and retirement, and any other compensation provided like bonuses, stock options, or commissions. Now, there is a fixed wage option in the bill. So if the job has a set non-negotiable pay rate, like $25 an hour, employers can list that single amount instead of the range. But you got to be careful there, because if you have other employees doing the same job and they're not earning that fixed amount, you may be out of compliance. Other provisions include that upon request, employers must provide the pay range for any new position to any current employee who is offered an internal transfer or a promotion to that position. The law also applies to any job that could be performed by Washington-based employees, even if the company is based elsewhere. Now, referring back to those common sense fixes that I mentioned in the beginning, the 2025 amendments added a cure period to the bill. So beginning in July of 2025, an applicant cannot sue an employer immediately. They or any person must first provide a written notice of the error, and if the employer fixes the post within 5 days, they're immune from the penalties. Employers are also no longer liable if third-party sites like Indeed scrape those ads and repost them without adding the necessary salary information. And finally, instead of the mandatory flat $5,000 fine, judges now have discretion to award damages between $100 and $5,000, depending on the severity and frequency of the violation. So again, I think those are some common sense fixes that make sense. And next, California. So on January 1st, minimum wage increased to $16.90 for the state of California. The state has dozens, literally dozens of other minimum wages for certain municipalities, lots of cities, even counties. But for the statewide, lowest you can pay is $16.90. Sick leave is now called safe time leave. So employees in California can now use their sick leave if they or a family member are victims of certain crimes. Leave can be used to attend court or judicial proceedings related to those crimes. And the provision now explicitly allows the use of paid sick leave for jury duty or to appear as a witness who's under subpoena. The next one is California's Assembly Bill 692, and this one makes it unlawful for an employer to include terms in a contract that would require a worker to repay a debt or penalty if they leave their job. So this includes things like training repayment agreement provisions. So those are those that require employees to pay back a certain cost of mandatory on-the-job training, or onboarding costs. So sometimes employers try to have contracts that mandate reimbursement for relocation expenses, visa, immigration fees, or equipment if they leave a job early. Now, there is an exception, a key exception. And I just actually attended a labor law update by a couple of attorneys yesterday that talked about this. You can still do sign-on and retention bonuses. However, to qualify, those bonuses must be interest-free, prorated over a period of no more than 2 years, and the employee must have the option to defer their payment until the end of the period to avoid any debt risk. They also have to be done as standalone contracts. They can't be written into an offer letter or any other agreement. They have to be on their own. And then finally, let's see here, we have California Senate Bill 513, and this expanded personnel files to include education and training records. So if an employer provides education or training, those records must be added to all personnel files, and the files are legally required to include 5 pieces of information: the employee's name, the training provider, the date and the duration of the training, core competencies of the training, and any certifications that were received because of the training. And then finally, so this is the last one we're going to touch on, Senate Bill 294. As of February 1st, so just a couple weeks ago, week and a half ago, all California employers must provide a new standalone written notice to every employee and all new hires moving forward. So that is to say, you have to give it to everybody you have and provide it to everybody you're getting. And then again, annually detailing their rights. So unlike the poster that's on the wall, this must be delivered directly to the employees via email, text, or in person. The notice must include information about their constitutional protections under the 4th and 5th Amendments during law enforcement interactions, like their right to remain silent, their right to refuse a search, etc. Must include a notice about the requirements of I-9 audits and the protections against unfair immigration-related retaliation, and a labor notice, which is the right to, a labor notice which states the right to organize a union and engage in a concerted activity. And then finally, a summary of all of their workers' comp rights. So this is something that is already in effect in California for those on-the-wall posters again. But now the state's saying you have to give this to all employees at the time of hire. And again, we're seeing more and more of that sort of thing in Oregon. So it wouldn't surprise me if Oregon followed suit here pretty shortly on something like this. And that's what I got.
Okay, well, let's open it up for questions on here. And I was trying to scroll through a little bit on your, Mindy asked, what date did the automatic enrollment of 401ks go into effect? And so that's just for plans started on December 29th, after December 29th, 2022. And that went into effect as of January 1st, 2025. Now, employers could have started it early. They certainly had that option to do so. Okay, scrolling through here. Lindsay, do you see any questions I'm missing?
Nora had asked, do the laws apply to businesses with less than 10 employees?
Ooh, would need clarification which laws on there. Exactly. Because the undue hardship for expressing milk in the workplace, you could only have an undue hardship if it's 10 or more employees, Tomas?
Correct.
That's your slide, so I'll defer to you.
Yeah, right. So that law does apply, but you could file for an undue hardship or request an undue hardship or claim an undue hardship if you have 10 or fewer employees and meet those other criteria that says it would be an undue hardship. Yeah, I'm trying to find the exact wording here. Let me get back to it.
So yeah, feel free to send straggler questions to that email on screen and we can get those forwarded to the right person. Last one was review the contractor pay liability, please.
So as we said, if a subcontractor or an employee, a worker on the job is not paid by their employer, so whoever the sub is perhaps, then that liability goes up the chain. It could go to the general contractor, it could go to the owner of the project. That's it in a nutshell. Now, again, there's exemptions there. It doesn't include work you do on your own home. It doesn't include certain smaller projects.
I think the definition of the smaller projects was 5 or fewer units
Correct.
of residential or commercial on a single tract. So it's a fairly large project on here. Yeah, the worrier in me for HR stuff for employers is that Oregon has been expanding things as a general statement. And so maybe they go after new groups on that instead of just those large projects.
Right. This is kind of
Hopefully
a foot in the door to get it started, and then it expands from there. I'd agree.
Okay. Okay, so age 60 to 63 can contribute more to their 401k. What about a 457? I'm not familiar with the 457, and to be honest, a lot of my knowledge is limited to the 401k. So I think that I know that, like, I'm pretty sure that the 403b mirrors that, but I don't know about a 457. Sorry, I'm not familiar with that. Okay, I think that wraps it up. Unless there's any questions I've missed, Lindsay or Tomas, have you checked?
That's all the questions I saw. Recording will be automatically sent once it saves and uploads to a link. If you have questions or want the PDF afterwards, feel free to email that support or my name, which is in the chat, to us, and we can get you the PDF of the slides if you'd like those. Thanks, Aaron and Tomas. Great job, guys.
Thank you for attending. Really appreciate it. Let us know if you have any questions. Have a great day, everybody.